to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Gracious God, we thank you for your mercy. We thank you for your love and your kindness. We pray that this meeting will accomplish the things that it needs to accomplish for those that are running for district office. We pray that each integrity, each honor, and the vigor of their compassion, God, will be brought forth, that those that are listening to them will be able to choose the right candidate. And we give your name the glory and honor. And we thank you, Lord, in Jesus' name. Amen.
Amen. All right, I'd like to welcome everybody to the joint veterans endorsement interviews for judicial candidates. On the outset, we'd like to thank and formally recognize the organizations that are here today to make this event possible. Veterans in Politics International, Nevada Veterans Associations, and Armed Forces Chambers. We also want to extend our sincerest appreciation to additional sponsors, community partners who have supported these endeavors and our professional, fair, and transparent endorsements. We'd like to thank Jacob Reynolds, who is running for Department 29, Mary Perry, who's running for Department P, Judge Veronica Birch, who's running for Department 5, Daniela Termu, who is candidate for Clark County Court District Department 28, Amanda Pazzarazzi for Municipal Court Department 1. We're honored to have all these judges here with us today. Before the interviews, let's set some rules. First, the panel members will all introduce themselves, and then you guys will tell us a little bit about you and introduce yourself. Please keep it short. Your responses short. Keep the lawyerese out. Don't duck questions. This is not a debate. You will answer our questions directly. You're not debating each other. When you see my hand go up like this, you will have 30 seconds to finish your question. It will go up again at 10, and then it will start counting down like this. You're done. You have about a minute and 30 seconds for each question. Try to answer them quicker if you can. Like I said, you'll see my hand go up. We don't have a red card. Panel members will not be permitted to ask follow-up questions. So either the judge did answer your question or they ducked it. With today's interviews, we will recognize the rest of our sponsors. Other than that, keep it professional. And let's begin with introductions down here with Bill.
My name is Bill Carnes. I am a panelist with the Nevada. Bill Carnes. I'm a panelist with Nevada Veterans Association.
Mike.
My name is Michael McDonald. I'm a panelist with Veterans in Politics and CEO of Family Unification Alliance.
Hi, my name is Bradford Carlton. I'm a panelist with the Armed Forces Chamber.
Good morning. My name is J.P. Edwards. I'm with the Armed Forces Chamber.
Frank Friends with Veterans in Politics and Family Court Observer.
Marilyn Caston. I'm running for Department R.
My name is Nick Petsas. I'm running for Family Court Department R.
Bill Henderson. I'm current 18-year incumbent in Department R.
Should be on.
Oh, it's low.
Too slow.
I mean, not you.
Go for it. I'm sorry. It was muted.
No, test.
There
we go.
Sorry about that.
Bill, you want to start with your first question?
Do I start this question generally or to any one?
However you'd like. You can go all three of them. You can go direct to any judge.
I'm going to ask these two because you're the incumbent, and that is describe the jurisdiction of the family court as laid out in NRS 3.223 and its limitations in authority of jurisdiction and also where there might be some overlaps in jurisdiction.
Thank you very much for that question, Bill.
That's not to you. That's to those two.
Okay.
So this is an interesting topic because family court is actually super jurisdictional. So they can hear matters outside of just family law, but it doesn't work the other way around. So family law matters get automatically assigned to family court. Divorces, custody, mental health of children, abuse and neglect, etc. But there's a lot of overlap in domestic violence and criminal matters, parental kidnapping that the family court judge can hear, and also other civil matters. And I've had this situation pop up a couple times, and I always appreciated when the judge was willing to exercise that super jurisdictional power to hear something. For example, in a complicated divorce, if we have an issue with an omitted asset after the fact, we want to come back to divorce court, judge who heard this matter, to decide what this business is worth that we forgot to mention in our divorce that needs to be valued and split up.
Thank you. And just to build on that as well, The area where I practice primarily is in family court and dependency, which is CPS cases, things like that. And so family court has jurisdiction. There's courtrooms who hear divorce and custody matters, guardianships. There's also the CPS cases, the dependency matters. And there's also delinquency matters, which is like the criminal system for minors, essentially. And so the family court has jurisdiction over all these different types of cases, as well as some of the issues we deal with, like Marilyn was saying, where you might have a kidnapping case where a parent takes a child out of state, things like that. We see that a lot in dependency, where we might have one parent here in Las Vegas and the child's removed by CPS, but the other parent is out of the state. And so oftentimes we'll have conferences where we are working on determining the jurisdiction for the state and what's the home state of the child and trying to figure that out as well. I'll stop there.
I figured you knew this.
Okay, yeah.
It's too easy for him.
All right, Mike.
Good morning. Thank you for being here. So first of all, the first question is, for each judge candidate and judge, so are you aware of what parental alienation is and pathogenic parenting, and have you watched the documentary Divorce Corp?
I have not watched that documentary, but I'm extremely aware of what parental alienation is, both in my personal and professional life. I'm divorced and remarried. I have a blended family, and I co-parented with an ex personally, so I'm aware of what that feels like, and it's not a fun thing to go through in your personal or professional life. From a court perspective and a legal perspective, it's very subtle and insidious, where it's hard to detect sometimes from the bench. Doing these cases, representing families for over 12 years that are going through this, I'm aware of it and what it takes to prove it, and it can be really, really difficult. It has an extreme detrimental effect on the child at issue. Being put between your parents, I describe as being a prisoner of war, not to aggrandize it, but you can't be happy no matter what, because if you show any excitement or love towards the other parent, you're punished at the other parent's house and you're discouraged from that. It's something that judges on family court need to be very aware of and know how to cut through and how to identify. We have children interviewed sometimes at the Family Mediation Center, and you need to be able to listen between the words and see why they're saying what they're saying, what's driving those comments, and get to the root of it. And therapy can be helpful, and different custodial decisions have to be made accordingly.
And you asked about two terms, alienation, and what was the other one? I'm sorry, I missed it.
Pathogenic parenting.
Okay. And so, and I have not seen that documentary, but I would like to, because I think it's really important to learn as much as possible about what's going on in areas that I may not be as familiar with. But oftentimes what I'm seeing as far as alienation are the most extreme cases of that. Spending so much time in dependency and CPS, I represent parents currently, and previously I represented children for years with legal aid as a cap attorney as well in CPS cases. So I have the experience of representing children who have experienced alienation from their parents, and also representing parents who are having that issue with other parents. And oftentimes in very extreme cases, that can show itself as one parent or a family member. Sometimes it's not the parent, but it might be family members or friends or someone else calling CPS, reporting things that may not be accurate. And CPS has that duty to investigate, and sometimes they might find something, sometimes they might not, but the record of that investigation stays with them. And that stays with them in CPS's internal systems as well. It may show an unsubstantiated investigation, but when and if that happens again, you're going to see that on the reports that come through. Same thing, I represent parents in dependency matters involving sex abuse as well, and I've had clients who have had criminal cases brought upon them by allegations that may or may not have been true. Based on the conversations I've had with my clients. And of course, it's important to take all of that seriously, but you also have to be able to read between the lines to serve the families and ensure that what's being told is actually the truth.
Thank you. Thank you very much. Thank you for that question, Mike. Now, we just heard some pretty decent definitions and observations about this, but the key point is, what do we do about it? That's the really difficult question. Let's say you have a child who's 6 and 8 and this has started, and now he or she is 14. What do we do? Give up? According to the definition of many judges and many attorneys, yes, let's apply the concept of teen discretion, where in those instances, teen discretion is often used to preclude the relationship. i.e. I'm not going to visit dad or mom at all. So I'm very aggressive and known for this about keeping people in reintegration or reunification therapy, and there's a lot of excellent ones who are reasonably priced. Nick Ponzo's one who can always adjust to the family's needs. I will keep them in there till everyone, including the parent who's aggrieved, if they say, uncle, I'm giving up, let's say dad or mom says, I don't want to pursue it anymore, and the specialist agrees it's pointless. But other than that, we claw through to the end. And I just had one where a relationship was restored at age 17 where there'd been no contact for several years.
So many lay people think that the law is kind of difficult to understand. So my question for all three of you is, in practical terms, what does best interest of the child mean to you?
Well, that's a really tough question to answer, right? That's the $1 million question. That's what people that don't practice family, that aren't in family court, always ask us, right? There's a list of 12 factors that were given in the statute, NRS 125C, but there's also any other factors, right? So there's different things like what Bill was just talking about. So parental alienation is something that has to come into play. There's different cultural issues that could come into play. I've had some recently with sexual identification where it matters, right? Like if there's a child that has some different issues and the parent's not supportive, should that matter or should it not? Anything that puts this child at the best chance of success in their life, but with contact between both parents, if it's reasonable and safe, is in the child's best interest. And I really feel that not only do we have a preference for that in Nevada for both parents to be involved, but I think we have, a constitutional duty to try to make sure on the bench that each parent gets contact as long as it's reasonable and safe. And if it's not, how do we make it reasonable and safe as opposed to using custody like a punishment? That's not in the child's best interest. Denying them contact with a parent to punish them is not going to benefit that child long term.
So when we're talking about best interest, kind of some of what Marilyn said, because what Marilyn said was fantastic. I think looking at all those factors is really important, and it's really also important to understand what the circumstances around the specific family before you. If you're sitting on the bench, family looks different for everybody. And so I've represented children who their family was not their blood relatives. There's under the statutes, NRS and also in 432B, which governs dependency CPS cases, but also has some overlap with 125C. There's also a concept of fictive kin we talk about, and that's someone who has an established relationship with the child. And that might be where this child has a godparent or has an uncle or has a family friend or a teacher or someone else who is willing to step in and take that parental role if the parents aren't available. Of course, your parents always have the rights there, right? But if the parents are not available or they are choosing not to be involved, there's also other members of that family. Now, on the bench for a domestic case, when we're talking about custody with parents, of course, the parents have that joint legal custody. And the default is that parents should both be able to have a strong relationship with their child, unless there's some other reason to deviate from that. That's the default. And so it's really important to look at the family dynamics, the individual dynamics of the family, and rule based on that. And I think that's what's going to point us to the right direction towards what's in the best interest of the child. And having represented children for years, I think that puts me in a unique position to be able to assess that.
First, thank you for that question, Brad. And I think as to those 12 factors, I think it's an attempt to codify and put into law what we as human beings already know, feel, and as our parental instincts. We don't really need those factors to tell us. The factors are legislative intent to, again, sort of codify real life human emotions, our priority and value system. Best interest, hard to define. It's subjective. It varies with opinions, but you know it when you see it. You see friends, family, and you say, is this child loved, cared for, adequately fed, adequately clothed, or and better than adequate, we hope to do as well as possible. Make sure the schooling and medical. If you see a child who the parents are right on top of medical, schooling, care, enough financial care, food, clothes, and activities and bonding and a lot of involvement, that's a good parent. If you don't see those things, to some extent we're lacking.
Panel members, make sure you state your name and your organization before every question.
Good morning, JP Edwards, Armed Forces Chamber. This question is for all of you. Where is it? How do you balance strict application of the law with compassion and emotionally charged family court matters?
That's a tough one, right? So this is a court, this is a judge, there's a winner and loser. You know, it's something where you have to take into consideration the best interests of the child, because you might have parents in front of you that have done something wrong, that have failed to follow an order, that have not adequately taken care of their child. And you have to balance that against nobody's perfect. Nobody in that courtroom is perfect. And, you know, is it something where you're going to try to punish that parent, and what you're really doing is punishing the child by taking them away from a parent that they love instead of giving them an avenue towards rehabilitation or getting back on the right track. And I always appreciated judges that took the time to provide a roadmap on how to get back into a good custodial situation, what was expected of them to prove that they could adequately take care of this child, and that it would be in the child's best interest to be with them at that point. And I think that giving them that compassion to be respectful and give them dignity no matter what their position is or what they've done when they're in court, because at the end of the day, this is their child, and it's something where they need guidance from the court, because like we mentioned, they don't know the law, they don't know what's expected of them or what their rights are, and a lot of them don't have attorneys with them. So treating them fairly and with dignity, and then also giving them an expectation of how to get back into the custodial graces.
So this is something that I deal with every day. This is Friday. This past Friday was the only day this last week that I was not in court. I'm in court constantly because I have a very large caseload of appointed parents to me. So I have about 170 clients that I currently represent, parents in CPS cases, and that's family court. And my entire career has been involved in service. I started as a teacher, working in Clark County School District here, and I worked at charter school here as well, teaching middle school. I've since represented kids and parents, and that service comes from a place of compassion. And having that compassion and understanding is going to underscore the decisions that I would make on the bench. However, you have to balance that with ensuring that the law is applied justly and fairly to every family. And we can say it generally because currently 2 of us are not on the bench, right? But at the same time, I'm spending so much time in court and understanding the repercussions of these rulings on my clients, on children, and being able to apply that law to the specific circumstances of that family and be able to come at that problem, because people are there because they have a problem, right? People don't show up to family court because everything's going great, right? Something's gone wrong. There's something that's broken down, and that's why they're at the court. And so being able to take those circumstances of the family and understand what's going on with them, be prepared, read everything, hear everything, and then make that decision to apply the law in a way that's both fair and compassionate. Thank you.
Thank you. JP, what you identified as the fascinating intersection of law and, shall we say, equity. Equity is the concept of basic fairness when there's no adequate remedy at law. What does that mean? It means when we're extolling form over substance, and strict application of the law is going to be detrimental to a family and children, and we need to arrive at a different result. There's a lot more discretion and equity in family court than there is in any other court. So it's strict, slavish, hyper-technical adherence to the black letter law can get you into far more trouble than your technical adherence to it on some occasions, because people are going to review that case on appeal, or whatever the case, and they'll say, what the hell was he or she thinking or doing? And you're not going to get any coverage or protection if you say, well, I was following NRS point that, it's not going to do you any good. And you want people on the bench who understand that this is an area of law where equity is far more applied than in any other area and must be applied in many cases. So thank you for that question, JP.
Frank Franz, Veterans in Politics. So we've had over a quarter century of studies with these family court cases. 70% of teen dropouts, pregnancy, drug uses, 20% of 20 times percent of the people that are in prison, 85% of them are criminals, 70% of them are juvenile criminals, and 279% of them will carry drugs and guns in their lifetime, and they share one statistic: raised by a single mother. If they were raised by a single father, they have almost the same predictable outcomes as somebody raised by 2 parents. Now that you're armed with this information, going forward, can you tell us that in the best interest of the child, would it not be to give primary physical custody at the beginning of a case until all evidentiary is heard to the father instead of judges who favor the mother, knowing that that's not the best probable outcome for the child?
So we can't promise results. We can never prejudge a case. And I've not found that to be my experience in practicing for over 12 years in front of all these different judges, that there's been a mother preference. But I do remember in the before AB 263 days, and there was a respect for de facto custody, which favored single parents, single mothers, because they typically took the child, they took possession and control of the child in the initial separation, right? So right when people break up and they don't know what their rights are, what the law is, that was a typical fact pattern. We introduced AB 263 for a reason, and we codified it into the law that it is supposed to be 50-50 from the day you walk into court, that it is not a preference to be given to mom and not a preference to be given to dad. Well, I don't think that we can reasonably say we shouldn't be giving a preference to mom and then turn around and say we should be giving preference to dad. So I would say we should respect the law, which is 50-50. Everybody walks in on equal footing. You enter that courthouse, it should be 50% of the time with mom, 50% of the time with dad, unless there's an additional why. There's abuse and neglect, there's drugs, there's alcohol. And so that should be the de facto temporary decision, barring abuse and neglect.
And I appreciate you sharing those statistics as well. And it's really important to understand the outcomes from these decisions. And currently, under the law, that's the default, is that both parents should have joint legal custody, right? And a joint physical as well. And what we see, or what I see typically in the cases that I'm working with, especially once a child's been removed by CPS, which is a government agency, right? Both parents have to work towards getting their child returned to their care. And depending on the circumstances that brought that child in, that can definitely affect which parent is going to have custody of the child when that case closes. One thing that I try to work with my clients, with my parents, is to ensure that when that case closes, because the goal is always reunification. That's the default goal. We want children with their parents. We know that's going to provide the best outcome. And when they're with their parents in a way that can be safe, and trying to eliminate any other barriers to the other parent being able to have custody as well. Like I might have a client who has some substance abuse issues, for example, and they're working on that, and they haven't gotten to that goal they need to be able to have their child placed in their care, but maybe the other parent has. And the other parent has custody of that child and the case closes. The judge can order a temporary custody order where it's still joint legal custody, but the parent who completed their case plan may have primary physical and the other parent will only have supervised visitation. So my goal is always to make sure that both parents have access and custody to that child if it can be safe to do so.
Frank, when I first started practicing as a young attorney, back when dinosaurs roamed the earth, it was almost automatic that moms would get custody, even if you showed, well, she left the kids alone, she's smoking crack with a boyfriend. It didn't matter. Fortunately, as my colleagues have identified, the statutes have been corrected. I think for the most parts, the judges follow it. Now, there's no blinking at the fact that those studies are real. I've been reading them for years about single parent homes, drug use, teen pregnancy, high school dropout, prison, et cetera, et cetera, et cetera. And I think it's sort of a dynamic of, if it's the single parent who's in the greatly inferior financial position, I think that that's often what contributes to this dynamic. So those statistics are there. You can't argue with them. But I think what the real focus and bottom line should be is that whenever possible, unless one of the parents is unfit, the critical issue, as you indicate, of having two parents as heavily involved as possible. I think that's the antidote.
Bill Carnes, Nevada Veterans Association. If you would please, this is for each of you, explain the key jurisdictional principles under the Uniform Child Custody Jurisdiction and Enforcement Act, and where, as a family court judge in Nevada, you may have authority or lack authority under jurisdiction to include things such as dealing with emergency jurisdiction principles on a visiting family or one that's split between states that has an initial custody under a different state for jurisdiction.
So that's a complicated question. You told us not to use legalese. I'm going to do my best. So the UCCJEA is our jurisdictional law that says wherever the child has lived for the past 6 months is where jurisdiction of the home state should be. I've had many cases where this has been a problem because of we're a transient city, right? I'm from here. I've lived here for 35 years, but people blow in and blow out. So where has the child lived for more than 6 months? Sometimes there isn't one place. I've had several cases where it's been a myriad of states they've lived. So then you have to get more creative and say, where is there's an emergency where we need to take jurisdiction just to issue a Band-Aid order to figure out where this child should be. There is authority under the UCCJEA to do that. Or we look at a different state and say, you know what, all the information about this child's schooling and medical history and friends and therapy is in a different state. We shouldn't be hearing this matter. California should be hearing it. Arizona should be hearing it, wherever the situation was. But Nevada judges can always make emergency Band-Aid interim orders under the UCCJEA just to protect that child, make sure there is a custodial parent if need be.
I'm really happy to hear that question because this is something that I deal with often in my practice. Actually, one of my client calls just yesterday, we were discussing a UCCJEA issue and having to explain that to a client who, again, we're not speaking legalese, right? If I'm talking to somebody, I have a client who's located out of state. And I'm talking to him right now because his daughter, he sent her to live with her mom. And that was for educational issues. He said, oh, the schools are better out in Clark County and than where he's living. And then mom got involved with CPS and CPS got involved. And now we're trying to figure out where should this case be heard. And because this child just came out to Nevada during the beginning of this last semester, which was right around December, January, right? It hasn't been 6 months yet. So the home state of that child is the previous state where the dad lives because she was there for years with him before they made that decision. And so currently there's an open CPS case. I'm talking to my client about it, but he's not necessarily part of this case, but we do have to work on getting jurisdiction back to determining whether or not jurisdiction should be back to that home state. And that's a complicated issue sometimes to bring up because you've got to get judges in contact with other judges. And certain states are better than others and certain locations are better than others at getting back to us. I know some of these San Bernardino County, some of these Southern California counties, they're so busy, they don't get back to us. But it's really important to make sure that we determine the jurisdiction so that the court can make those rulings. Thank you.
Bill, those cases can be nightmares. When I have one of those, I wish one of these two were on the bench instead of me at that time. Because let me tell you, I had a mentor once. He said, what do you think parents are the most dishonest about? I said, custody matters. He said, no. Oh, I got a child support. He said, no. He said, it's these jurisdictional issues. It's always so hard to figure out. She told me she was just going to Michigan to get on her feet, to give us a separation for a month or two and stay with her folks there. What is he talking about? He knew it was permanent. He rented the U-Haul for me and helped me load it up. So what I think is really critical to determine in these things, we can't always get sucked into just the technicalities of who's been where, how long, because if someone's been holding the children, almost an abduction in some situations, in another state for 6 months, and then they say, I have 6 months. No, time out. Let's look at what was happening from a human element. What was the intent? What was the understanding? If you just took the children without his or her consent and then waited till the clock hit 6 months in another state and then you file, no, that's wrong. We have to examine the human element, what's right, what's equitable, what was the understanding, what effect this is going to have on the rights of the parent who remains behind, and all the expense and time it would take to maintain a relationship. So I always want to know the story, and I want to hear it under oath.
1 second, Mike. So that the people can get to know you guys a little better. This is going to be rapid fire questions. Please keep the legalese out of it. We're going to go down to 1 minute responses.
Okay. Hello. All right. So, Michael McDonald with BIPI. So, I have a really important question. So, it sounds like all the judges here are potential judges and judge are in agreement that joint physical custody is a preference, should be a standard, in my opinion. You should have that set standard because it's not equitable when you have something that is you go to court and you have to prove that you're a fit mother or father. Well, how can you discern? There's a lot of mudslinging in family court. So what would you do to discern whether there's the silver bullet, which is false allegations of abuse? A lot of parents lose custody or visitation based on those false allegations, and it causes a detrimental effect to the child and causes all kinds of psychological issues. What would you do to discern for false allegations of abuse and to make sure that the fundamental right of a parent is protected and that they're able to see and be in the children's life as much as possible?
Sure. Like parental alienation, that's an insidious one, right? So that's something that can be really hard to discern and figure out what is the difference, what is the truth. We always, joke around in my office that there's our client side, the other client side, and the truth is somewhere in the middle, right? So we have to be able to get to that. And there's lots of different things we can do. We can review the text messages. We can review the factual situation. If someone's coming to court and saying there's abuse, did they wait 6 months to report it? Did they ever call the police? What did the police find? Can the officer come and testify about whether they believed this situation occurred or not? There's forensic evaluations that can be done. The child can speak. They can be interviewed depending on how old they are and corroborate the story or say, no, my mom told me to say that. My dad told me to say that. And you can read between the lines like I was speaking before. If you have experience doing these cases over and over again, like I do, and like it sounds like everyone on this panel does, you can learn the difference between someone who's just doing it for custody and who's trying to actually prove abuse.
And you're absolutely right. This is a huge issue that goes on with custody, right? You have one parent who's determined that they're going to have their children and they're going to punish the other parent. And I see this often. And again, having served so much time representing parents and children in abuse neglect cases, I've gotten really good at being able to see what's real and what's not real, and what's showing up in the reports and what's the actual story. I know I read tons and tons of these reports from CPS, the initial protective custody hearing report where the removal is actually occurring, all of the allegations against the parent, reading all the notes of what the parents are saying. But when you talk to the parents, when I talk to my client or I talk to the other parent's attorney, if they're represented, of course, I'm not going to talk to them directly, you can get a lot more insight than what's in a report. Same thing with the children. When you talk to kids, you can get a lot more insight. And being able to know all of that information plus the actual knowledge from the people, from the families themselves, is going to allow me to be able to make those decisions.
Yeah, I agree with my esteemed colleagues. You look at the documentation plus the examination on the stand is really telling. But the nugget we always have to remember, and one of them hit on it, and I think it's probably the most important point from a human behavioral standpoint. What did you do at the time? If you didn't do something consistent with, oh my God, my child was beaten, molested, we are not going to believe you. Did you immediately call CPS? Did you call the police? Do we have a pediatrician report? Did the mandatory reporter get involved? These are some of the things we need to examine. If you didn't act at the time, then you're admitting that whether or not these allegations are true, you are unable to protect the child. So you're not an appropriate parent if you didn't act.
Bradford Carlton, Armed Forces Chamber. So as we know, legal services are expensive, and you're going to see a lot of people who are representing themselves pro se. So with that fact, how would you handle self-represented litigants who may not necessarily understand court procedure? And I'd like to start with the judge first.
Thank you for that, Brad. The fact of the matter is that I'm heavily involved with the Legal Aid Society of Southern Nevada. I really do a drill in on these people and their finances. And I say, please report down there, particularly if it's something contested. Please tell them the judge urged that they assign someone to you, because I think that's absolutely critical. And there's also other settlement programs. My department's in charge of the Judicial Settlement Program, which I formed years ago. And that's a way to get people who are marginally represented or people who are unrepresented at all. It's a way to get them in and out of the system as economically, as quickly as possible. And often I'll just negotiate right there as more of one of these simple cases right in court and get it over with, if that's when that can be done.
So thank you for that question. I have worked with Legal Aid Center as well. I help with the Ask a Lawyer weekly sessions, so I answer people's questions just in 15-minute sessions, giving them as much advice as possible because I really believe in access to justice. Whether you can afford it or not should not determine what happens in family court. But to answer your question, how I would treat them, I'm really thankful for some of the other judges. I think it was Judge Gordon and I think Justice Patricia Lee that created the program where if there's no lawyer on either side, the judge can take over the process to help ask questions that they need to know, because there's a disconnect between people that don't have a lawyer and what do I bring to court? What do I say at court? How do I prove this? How do I get my evidence in so they'll actually consider it? When they turn that process over to the judge in this program, the judge can look at everything and ask questions and get to the meat of the case, find out if there's been parental alienation, find out if there's been abuse, and make the best decision instead of expecting these pro ses to do it themselves and dealing with the travesty of the decision afterwards for years.
And this is probably one of the most important things for a judge, and having people before the court who do not have attorneys, who don't know really what's going on in court, because that's something that I deal with every single day. I've been representing parents for years. I've represented children for years, and being able to explain these complex concepts without the legalese, right, in a way that they understand and is going to allow them to understand, number one, what's going on in court that day. Because I'll have clients who are represented by me and afterwards are talking to me, what happened today? And they were there. And it's really difficult to understand all of that. And so being able to not only have families who may not have attorneys because they are very expensive to come in before you and to be able to explain things in a way that they understand, take some of that fear and unknown out of it so that we can dial down into the issues that need to be solved. Asking the right questions, like Marilyn said. Also, working with legal aid. I was a legal aid employee for years representing children too. I love that my colleagues have represented or volunteered time with legal aid. It's so important. They have great resources for families as well.
JP Edwards, Armed Forces Chamber. I think each and every one of you has stated at some point in time about the caseload that you have as far as family court goes. So my question is for all of you. Family court often faces heavy caseloads. How would you ensure cases are handled efficiently without sacrificing fairness?
This is a hot button for me. This is something I am very frustrated with in my own personal, professional life when I'm dealing with these families that are waiting years for their court date. They're waiting for orders. They're waiting. I just did a trial in October and I just got the decree yesterday. 4 months later, I got the decree. This family lived in agony, not knowing what they were going to be able to keep and not keep, when they were going to have their kids and not have their kids. It's something that we need to fix, right? That's one of the reasons why I'm running, is to try to fix the efficiency of the courtroom. Every family deserves their time, but there's better ways to run the courtroom where each family does get their time, where trials can be set in a timely manner. They get enough time to do the trial, because that's another frustration. I'd like to see anybody prove a divorce in 90 minutes, which is a typical time allotment that we get. It's ridiculous. We need actual sufficient time. And the way to do that is to status check the case instead of just setting the trial, see you in 6 months, 9 months, a year, and then, oh, wait, we're not ready. We don't have everything we need. We have to reset it even farther. My calendar's pushed out for a year. We need better track of the cases during the time that the case is being litigated, and then set the trial.
Yeah, and efficiency is something that I think is a hot button issue for all of us. And, that's something that, in the courtroom there where I primarily have practiced, we have to be, if not the busiest, probably one of the busiest family courtrooms for CPS cases. Like I said, I was in court last week, 4 of the 5 days of the week. One of them was for an evidentiary hearing, because we have those when we don't have regular cases. I think we set a record this past Tuesday where we had more cases on than we've ever had on a Tuesday, which is our regular calendar day. And we were going from 9 o'clock in the morning and we finished sometime after 5. Our lunch was way late and all of that. So it's a big issue, right? And families are waiting for hours to even have their cases heard. The dates get pushed back. The orders get pushed back. One of the things that I would be doing is, your time in the courtroom working isn't just when you're working, right? As a teacher, you're grading papers and making lessons outside of the school day. That's what I was doing as a teacher. Same thing here. I'm preparing for cases well in advance with these huge calendars. I will ensure that I'm prepared for every single case coming in front of me so that we can get as much done as we can while they're there and stop having to have families come back over and over and over again.
In my department, if someone wants to get into trial in 4 months, 1 month, whatever, they can do it. Why? Unlike, I think, virtually every other department, and one of them alluded to it here, they automatically, when they send out the first notice on the case, they assign a court trial date. 98% of the time, and one of them just discussed it, it's going to get continued because we're not done with preparation, et cetera, et cetera. So I tell people, let's wait. You tell me when you're ready. I don't want to keep studying these dates, clog up calendars, and everything's 8 or 10 or 12 months out like it is in a lot of other departments. You tell me when you're prepared, you have everything you need. Then you tell me when you want to go. If you want to go in 4 months or 2 months with cancellations and continuances, I can fit people in anywhere they want. And as far as 90-minute trials, if people need 4 days or whatever they legitimately need, that's what we're going to find them. Thank you.
Frank Friends, Veterans in Politics. So lately we've seen a lot of cases with parents taking children to another state to trans the child. WPATH just did a 12-year study that proved exactly what we knew, that if you give children puberty blockers and if you start to transition them, their suicide rate jumps to 40 to 42%. However, if you just leave them alone and let them go through puberty, most of the time they just become gay or bisexual adults with no further proclivities towards the transitioning issue. Given that you now have this knowledge, how would you feel if a case came in front of you where a parent was trying to take a child to another state to transition them over the best interest of the child and of the parent in the case matter? And Judge, we'll start with you and work this way down.
Yeah, thank you for that, Frank. And it's not just this is a dynamic that whether they're in the state or not. Although, as you suggest, some people may move to the child to another state so they have more flexibility to do this without being under the supervision or gun or vision of the court. I'm very, very sensitive to this issue and children developing in the form and the inclination that they're meant to. On the other hand, I strongly agree with you that it makes sense to wait till a child is 17, 18 and let them decide. Because there are boys who, like at 14, will start putting on makeup and such, and even wearing girls' clothes. And then the same boy you see 4 years later, he's transitioned out of that. He's on the football team, whatever. So I think we need to wait a little and let this thing evolve. And as Frank says, in due time, their inclination more often than not will be known.
This is a really important issue for any family who's going through something like that, right? Where if the child's indicating that they want to transition in some way, and maybe one parent supports that, one parent doesn't, ultimately, that's medical care, that's mental health care, that's all of these things to ensure that the child is cared for, and those are decisions that need to be made by the parents. The court should step in if there needs to be some kind of dispute resolved in that way, right? So if the parents are deciding to do something and they're jointly deciding it, if they're within the law and within their rights as parents, it's the parents' decision combined. But if one parent is against it, one parent's for it, one parent's trying to take the child out of state for what amounts to medical treatment, medical procedures, things like that, that's the issue right there, right? And the thing with that is that it's very dependent on the unique circumstances, but you have to look very carefully at the reasoning behind it and the situation of the family before making that decision.
So it's a really tough question. This involves legal custody, which is decision-making power over your own children, right? It's a constitutional right that each parent has. And when parents don't agree, let's say one parent is in favor of the transition and one parent is not, the court has to act as the final tiebreaker and has to hear that case and decide what's in the child's best interest. So to answer your question, those statistics really matter when you're talking about how do I navigate this as the judge? Should I order that it be done or not be done? You have to look at all the evidence, all the academic statistics and research, which does support, I believe, your position.
Okay, judges. So that's going to conclude this, but we're going to give you each 1 minute to discuss as to why you are the best person for this job and where people can reach you, starting with the judge.
I'm Bill Henderson. I can always be reached on my cell, easy to remember, 702-460-6000, 460-6000. I'll write it down and email it to anyone who wants. And a big issue in family court from this organization's perspective is transparency. Everyone comes here and says, oh yeah, open courts, open files, transparency, but very few do. As people in this organization can attest, unless it's one of those narrow areas of law or highly sensitive case that's closed, I don't let people clear courtrooms. I don't let lawyers clear courtrooms. Everyone can attend, and I'm not inclined to sign these orders to seal the files. So courtrooms are open, files are open, except if it's very narrow issues like juvenile or highly sensitive issues under law. And then it's a balancing test, compelling interest. But most of the time, the public's rights for visibility and transparency trump the matter.
Thank you. And as you all know, you all have been involved in service to our country, and we all are very appreciative of that. That's something that's really important, is service. Throughout my career, I've been involved in service as well. And I've had the opportunity, I've had some experiences in other areas in private sector. However, I keep being drawn back to public service. First as a teacher, then as an attorney. I'm representing the people who can't afford attorneys in some of the most difficult cases of their lives. I've stood beside these parents as they've had these decisions made that are going to affect not only their life, their children's lives, and their families' lives forever. And I understand how important that is. I've worked with children, both as a teacher and as an attorney, and I understand how those decisions affect them as well. I bring all of that to the bench to let you all know that I will continue to serve the community and know what people's stories are, how our community lives, and be able to make those decisions that are going to be best for those families. Thank you.
All right, my name is Marilyn Caston. I'm also running for this department. Just to tell you about myself, I grew up here. I'm from grade school all the way to UNLV twice and for law school. It's something where I care really deeply about this valley. I've lived this life. I've been divorced and remarried and dealt with, not seeing my kid on holidays, not being able to be at certain events. I've dealt with this in my professional life for over 12 years where I've been representing families. There's a lot of topics we didn't talk about here today. We didn't talk about child support, termination of parental rights, relocation, school choice. I've handled thousands of cases in this department in every single area of this area of the law, and I'm happy to bring that experience, but personal empathy as well, to treat everybody with respect and dignity. We need to fix this system. Everybody in this room probably has the opinion that family court is broken, right? This is something where I hear over and over again in my cases, over and over on the streets when I'm talking to voters. That's why I'm running, is to try to bring transparency and accountability and efficiency back to the court.
All right.
Thank you. Thanks for taking the time on a Saturday to be here at 8 a.m.
Thank you, Facebook followers and everybody on the panel. Thank you, judges, for coming out. Thank you to our sponsors. That will conclude this interview at this time.